You are watching the Lemonade Podcast with Amar Law Group. Join us as we unlock the secrets and expert tips you need to know now.
Hi, everybody. Welcome to episode 3 of the Lemonade Podcast. I'm Matt Sky. With us is Shalev Amar, managing partner and founder of Amar Law Group. Shalev brings a wealth of experience in consumer protection law, specializing in lemon law and breach of warranty cases. Shalev, thanks for joining us.
Thanks for having me.
So let's get right into it. With vehicles becoming more connected and automated, what challenges do consumers face in proving defects under lemon law?
I'd say the biggest challenge is most vehicles have onboard diagnostic systems these days that spit out what are called diagnostic trouble codes, or DTCs. So those are codes that the onboard computer will throw out, and there's tools that can be used to connect to the computer to evaluate the diagnostic trouble codes. And so these days, a lot of vehicle companies have become overly reliant on DTCs and just kind of have the attitude that, oh, if there's not a code saying there's a transmission problem or a shifting problem or a starting problem or an engine problem or some kind of electric issue, if the computer didn't see it, then it didn't happen. But that's obviously not the case. I mean, there could be all kinds of problems that a computer will not pick up. Computers are not infallible. They're not perfect. For example, if the vehicle's vibrating, that might not have a trouble code. If the vehicle's improperly shifting, even though it's supposed to give you a trouble code, it might not. You know, the onboard diagnostics sometimes misses things. And so I'd say that's the biggest challenge these days is over-reliance on technology, and then an assumption that if the computer's diagnostics don't find a trouble code, that nothing happened. That's definitely not the case.
So what are some specific examples of how new vehicle technologies have led to unique new lemon law cases?
There's various ways. I would say the most common is a lot of newer vehicles have a lot of software and different types of modules and computers. So those, obviously, anybody who's had a computer crash knows that the fact that it's a newer technology doesn't mean it can't break down on you. And so, you know, there can be trouble with the computer systems. There could be trouble with the software. There could be trouble with various sensors. And so I'd say those are the most common challenges.
Are there particular types of vehicles that tend to result in more lemon law claims? You were mentioning a little bit about all the new technology.
I would say not necessarily. It just really depends. There's some people who think like, oh, well, with electric vehicles, well, there's less parts, so there'll be less lemons. Well, not necessarily. There can be software glitches, there can be sensor glitches, there can be diagnostic system glitches, there can be computer glitches, there can be battery glitches. All other parts of a vehicle, you know, like the wheels, the brakes, suspension, still plenty of things that can go wrong with newer vehicles.
Of all these different areas, is there one where you see the most problems, the most glitches, where things get most lemon-like?
The more high-tech the vehicle is, the more we tend to see software problems and onboard computer problems.
Can you detail for us a little more how software and electronic systems in modern vehicles are influencing lemon law disputes? We did touch on it a little bit, but we'd love to hear more.
Sure. Well, look, especially with an electric vehicle, if the software doesn't work, the entire vehicle might not work. It might not even start, or the dashboard can go completely blank on you. You can't even see the speedometer. Your entertainment system doesn't work. The cameras don't work. So, you know, if there's a software problem, the entire vehicle might not work, or it could even be dangerous. Like you could get in accidents. Like it's been in the news how with some vehicles, their auto drive feature, you know, tends to be problematic. There's been people who've even gotten in accidents. And so it just because the technology is more advanced doesn't mean it's not going to have problems. And especially when it's a new technology, typically there's kinks to work out. And so although these new features are great, I recently got an electric vehicle myself. I love it. It's fast. One time the software went out and I couldn't see anything on the dashboard. I couldn't tell how fast I was going. So although the features are cool and fun and efficient to use when they work, it doesn't mean that they can't glitch at all.
When you have electronics that glitch like that, how do you prove something went wrong with the vehicle? It almost seems more complex when it gets more technological. Am I wrong?
Well, it might be more difficult to prove, again, if the diagnostics aren't working properly. But these days, there's ways around that. Like you can record things on your phone that you're experiencing as proof. And one of the challenges is that some companies try and argue, well, if we did a software update to address an issue, then, well, that's not really a repair. It's just software. Well, that's not the way I see it. If you're having to go to the repair shop, if you're inconvenienced, if you're out without your vehicle, that is, for a period of time, that's still a repair under warranty that would entitle you to lemon law coverage. I don't see the distinction between software and any other type of repair, but that's what some companies try to argue.
How effectively do they argue that, just out of curiosity?
Well, we haven't had to litigate the issue, but the way I read the law, it's very broad, the language of most state lemon laws. What it applies to are defects, nonconformities, or conditions. So I believe that software would definitely fall under all three of those, actually. But even if they're able to persuade a judge, well, this is not really a defect because it's software, it's definitely a nonconformity if the vehicle is not functioning properly. It's definitely a condition that's occurring in the vehicle. If you can't see the speedometer or if it's not accelerating properly, that's a problematic condition that the vehicle is experiencing. When you have attorneys or legally trained representatives, of course, they're going to try and throw spaghetti on the wall and see what sticks and try and make new arguments that are basically legal acrobatics. I don't believe they're going to get very far with that.
So let's say you hit a really complex case where there is some kind of electronic problem. Maybe it's a software problem like we're highlighting. And then there are subsequent severe injuries, which would not be inconceivable in a case like that. Do you coordinate with injury law attorneys, or how do you handle the complexity of a case like that?
Yeah, if there's physical injury, there are law firms that we would refer the consumer out to because we don't handle injury matters. But that would typically fall under personal injury law or potentially what's called products liability law.
Are there differences in how lemon law statutes address mechanical versus electronic issues?
I don't believe so. Again, because lemon laws are very broadly worded. And so, look, anybody can argue anything. You can argue the sky's purple, but it's just not necessarily going to fly. The analysis under the lemon law is always the same. And what that is the vehicle's repair history unreasonable? That means, are there too many repair attempts under warranty for a substantial defect, nonconformity, or condition? Or is the vehicle in the repair shop for too long, typically 30 or more days in the repair shop? So that's the evaluation. Now, the second element of the lemon law that you also have to look at, even if you're able to prove that the repair history is unreasonable, is the vehicle substantially impaired in use and value? So let's say you're having a cup holder issue. There's obviously some impairment. It could be irritating if it's rattling, but is that substantial? Well, arguably not. On the other hand, if the vehicle is not starting, if the vehicle is not accelerating properly, does the instrument panel go blank and you can't see the speed that you're going? Are those things substantial? Definitely. Then you have kind of more gray areas like, let's say, navigation or your entertainment system. That's not necessarily imperative to the functioning of your vehicle, but that could be argued both ways. I would say that if it's kind of a middle of the road type issue, like I said, like the entertainment system not working or your navigation not working, that if it happens more times, if there's more repair attempts, for example, like it doesn't just happen 3 or 4 times, like let's say it happens 6 or 7 times, I'd say even if you can argue that that's not imperative to the functioning of the vehicle, the fact that it's happened so many times makes it more substantial, makes it more likely to substantially impair the use and value of the vehicle.
And when you go to trial for a case, for a lemon law case, how long does that process take? And how long does it take if you don't go to trial usually?
Well, luckily, it's very rare to have to go all the way to trial in a lemon law case. I've been handling lemon law matters 20 plus years in multiple law firms. And I would say historically, in all the firms I've worked at, 95+% of our cases do settle out of court when it's a lemon law claim. Why is that? It's not the goodness of the company's heart. It's because, the statutes, they have presumptions, and if it's a reputable, that is, lemon law firm, they're going to provide a free evaluation, and they're going to want to review the vehicle repair records and screen the case before they take it on, because look, they don't want to waste your time, and you also have a legal reputation as a law firm that you don't want to hurt. You want the companies to know that if you're bringing a claim, that it's likely that it's a legitimate claim. And so when it is a legitimate claim, just in most cases, unless they have a major defense, like say, turns out that the vehicle was wrecked and that's the cause of repairs, or that the consumer has failed to maintain the vehicle, hasn't gotten proper oil changes or software updates to the vehicle, so they're at least partly to blame for the vehicle problems. Apart from those types of cases, the company, they're going to settle because it's just a financially insane decision not to settle out of court. Because if they lose a trial, they could have to pay attorney's fees. And I can tell you, to go all the way to trial, it could be 50 to 100 grand in attorney's fees. So if they settle out of court, the fees are obviously way less than that. Most law firms have flat fees of, depending on the region of the country and depending on the cost of the vehicle, it's typically anywhere from $3,000 to $5,000 flat fees. It's a very expensive product. A more complicated product like a motorhome, it could be as high as $7,000. But in any event, that's way less in attorney's fees for them to pay to settle than losing a trial. Because not only would they have to pay your attorney's fees if they lost a trial, they have to pay their own attorney to defend the case, which could cost them another 50 to 100 grand. So it's just a stupid financial decision in most cases to be out anywhere from collectively 100 to 200 grand if they lose the case, plus having to buy back or replace the vehicle or provide compensation depending on the type of case it is. And even if they win the case, if they're in a state where they can't get their attorney's fees reimbursed, and in most states they cannot, they're still out. Even if they win, they're still out 50 to 100 grand. So again, it just doesn't make financial sense for the companies to fight valid claims. But sometimes they feel they have a defense or that the claim is not valid for whatever reason. Those are cases that they might make a lowball offer or reject the claim out of court and therefore force a lawsuit if it is a valid claim. But that's very rare, especially if it's a reputable law firm that pre-screens the cases to make sure they qualify before they take them on. And
how common are those lowball offers?
Well, it really depends on the firm, frankly. We very rarely get lowball offers. It's, it depends, but it's maybe in 10% of cases. Sometimes they'll start with a lowball offer, but then they'll be willing to negotiate. But I'd say as far as making a lowball offer and sticking to it, it's maybe 5 to 10%, depending on the time of year, if you're a reputable law firm. By reputable, they know that you only take on valid cases, number one, and number two, you have a winning record in court, which we do. Now, if it's a law firm that tends to have a worse reputation, tends to take invalid cases or cases that are very weak, or they're a law firm that's known not to litigate, not to file lawsuits, or even if they do, they have a terrible losing record, then they're more likely to get lowball type offers.
How do manufacturers and legal experts adapt to new technologies when handling lemon law cases?
I would say that the main thing is they try and come up with new arguments. And so if it's a new technology, they'll try and make arguments, for example, like, oh, well, this is really a design defect. It's not a defect in materials and workmanship. Therefore, the traditional state lemon law should not apply because it's supposed to be for breach of warranty. And if it's a design defect, well, we're not necessarily breaching the warranty because it's not a defect in materials and workmanship. It's just an engineering issue to do with new products. Therefore, the law should not apply here. Now, that's their argument. There's a small percentage of courts who bought that. Most courts do not. And I would say also that my reading of the lemon law is that it's broad enough to encompass even design defects, because that would fall under potentially a condition with the vehicle. So let's say it's not a manufacturing defect, it's not a nonconformity, because if it's a design issue, all the vehicles have the issue. I would still say it's a condition with the vehicle if it's problematic. So let's say, the vehicle's not running properly, or it keeps cutting out, or it's a fire risk. Well, that's a condition with the vehicle. So a condition is part of the Lemon Law. So even if it's technically not a defect, it's still a condition.
And if you have one key takeaway for this episode, what would that be?
I would say to just keep in mind that as technologies evolve, it doesn't mean that legal rights evolve. The way lemon laws are written is pretty broad, and it's to contemplate changes in technology and advancements. Because again, at the heart of the lemon law, it's still, did you get what you pay for? Is the repair history with the vehicle unreasonable? Are you in the repair shop too many times? Are you without your vehicle for too long? And so if that's the case, whatever the cause, I would say in the vast majority of situations, you would still be entitled to lemon law protection.
Well, that's been our show. Thanks again for listening to the Lemonade Podcast. The Amar Law Group legal team operates throughout the West and Southwest. Check them out on social media and the links below. If you're in the Arizona area, find them on ArizonaLemonLawAdvocates.com or enter your state and LemonLawAdvocates.com. Shalev, thanks so much for your time.
Thanks for having me.
Thanks for watching. Be sure to hit that like and subscribe button and comment below.